Before we start talking about everything as it relates to Tori Woods and their book DLT, I want to offer some trigger warnings. So please stop watching this video and take care of yourself and your mental health, especially if you might be triggered by anything as it relates to PDO, which is the short for those people. Also, anything as it relates to CSA, anything non-consensual, R-ing, thoughts about minors, or just anything of that like. Again, I'm not saying this video will be covering all of this, but there are sections throughout our discussion where we do touch on these topics. So again, please stop watching and take care of yourselves. Now, I want us to get into some case law. Now, we are not lawyers. We are also not reporters or anything like that. However, I want us to bring our attention to the Department of Justice. Okay, I don't think there's a better source out there than the DOJ itself. This is from their criminal division. Now, I'm not going to read everything, but this particular screen grab that is on screen has to do with obscenity. And it says the Supreme Court has ruled that, and I quote, transmitting obscenity and child P, whether via the internet or other means, is illegal under federal law for both adults and juveniles. And this is Reno v. ACLU 521 US 844 1998. Now I'm going to read the last part. It's illegal under federal law for both adults and juveniles. Now, again, for adult consumption is one thing, but they're saying even for adult consumption, this is illegal. It also gets into further detail under the fact that it's not protected under First Amendment rights to free speech. There are violations. Now, I do have to mention the US court uses a three-pronged test, commonly referred to as the Miller test, to determine if given material is obscene. And it goes on to say, obscenity is defined as anything that fits the criteria of the Miller test, which is the three-pronged test, which may include, for example, visual depictions, spoken words, or written text. Again, it goes back to the fact people often say written text is protected. But no, under US law, under the government, as stated by the Supreme Court in their recent ruling, the recent one is 1998, but this goes back to the 70s. But what they're saying, it's not just video, it's not just spoken, also written text is also liable. Now, again, it has a whole thing. There's a link in the video's description. You can go read it as to the three-pronged test that a certain piece of material, whether video, spoken, or text, needs to meet in order to, pass the Miller test and is considered as obscene and as a result would be banned and maybe the person would be prosecuted. I don't know. However, we also have the NCAC, the National Coalition Against Censorship. Again, there's a link in the video's description because I want us to get educated, okay? We're not just here to just talk about the issue and the author being arrested and everything. I think it's also a great opportunity for us to get educated. Now, on this, they mention the prosecution of a fiction web host that really was putting that law that I quoted above to the test. So this was a case that was seen as a test of whether text-only fiction can be considered legally obscene. It goes into detail about the person who has been indicted on 7 counts of obscenity-related crimes for hosting this fiction archive. The site contained 25,000 stories by more than 2,200 authors. Now, it mentions that there were previous failures as it relates to Henry Miller's Tropic of Cancer in 1964, William S. Burroughs' Naked Lunch in 1965. And they're saying since that time, there has been no further attempts to criminalize long-form fiction in the United States. However, they mention fiction is not categorically exempt from the law. And then it goes on to state a case law of 1973 of Kaplan v. California, and the Supreme Court affirmed that words alone can be legally obscene in the sense of being unprotected by the First Amendment. Again, I'm not going to go into further reading of what this is, but essentially, we have seen the Supreme Court affirm in more than one case that, hey, it can be obscene. And again, it has to pass this. If it passes this 3 test, that is the whole situation. You can read more about this particular web host case, because experts were arguing that there is artistic value to this, that there is scientific value to this as well. So yeah, it's a whole thing. It's a whole thing. But Fran, I know when we were talking about this, you were mentioning this might be the case that some bright-eyed, eager, bushy-tailed attorney or district attorney or however it's done, wherever it's at, will use this now to go after our books. I mean, how are you feeling now knowing that this is DOJ's procedures? This is what the Supreme Court has said. We have essentially been here before. They have a framework. And essentially, if this is not proven to be valuable artistic expression, cultural, thinking, critical, anything, stuff might get banned.
Yeah. And I think that the issue is that all of that, all the tests and all the proving that it has value, it's all subjective, right? It's somebody's opinion of what is that thing, like what is going to pass. So it's all going to be based on somebody's opinion. And like you said, it's just going to take one person that is a little bit, excited about this thing, and everything is up for then being banned, because oh, look, it has sex, so we can't have that. So I think it's just a very, very slippery slope to go down when it comes to prosecuting things like that. I think that a private business like Amazon has every right to say, I don't want to sell this on my platform, because that's a private business making a decision. And again, this is work before for authors. Like Laura was saying, this is not the first time, it's not going to be the last time that an author that writes romance, especially the very, like, let's call it a little bit shorter type of straddling a line that is questionable, there is definitely a market for that. And I think I've said this before, that line where it comes to that niche of romance, it's very blurred. People have different opinions. Somebody may feel, oh, this is good enough because the book was set in a state where child marriage laws are XYZ. So there's a huge blurred line. And what this is going to do is, it opens up to prosecution. But I feel like what we should try to steer clear is going down that legal route. Let businesses make business decisions. Amazon doesn't want to sell it, that's fine. And what's happened in the past is when Amazon decides to ban something from the Amazon platform, the author then sells that book on their website. And the readers that want to engage with that content go to the author and they buy it. And that hasn't taken away the right for people to make that determination of what is the line for them. And I think that at the end of the day, that's important. I think what, it's in a way, like, we don't want to have certain type of material readily available. If it's only sold on the author's website, for example, I don't consider that readily available. You're not going to find a child randomly scrolling through Amazon and buying or reading that material, because they would have to literally go out and seek it. So I think that that's fine. We should let people be people, do what works for them, because I know that in that specific sub niche, there are so many blurred lines. I mean, the CSA is one of them, but let me tell you, there's so many other ones. Like, I know that there are, I know probably most of the things we can't say on the live, but there's books where, it gets into like paranormal, but there's like dead people, and like there's all kinds of stuff. And I'm not here to judge what people want to read. So if they want to go and read that stuff, there's stalkers, there's Stockholm syndrome, there's people that have been kidnapped and tortured, and then they fall in love with their kidnapper and torturer. It's like, just it's not for me to be the morality police. That's basically what I'm getting at. But the availability, I understand, and we can make it harder for people to get certain stuff that's questionable.
I have a question though, because the law, because I know we often refer to children, and most laws are all about protecting children, protecting children. However, this is also saying it's not appropriate for adults either. That's my reading and my understanding. So if it's not appropriate for adults,
That's the concerning part. And the
Laura,
concerning part is that we're seeing that the precedent is there, like the law is there. So then what is that speaking for in terms of like freedom of expression? Like, okay, so well, that doesn't really exist because the law to curb that is there. So it hasn't been used in the past, but that doesn't mean that tomorrow somebody couldn't just use it.
Liz is saying this opens up a valuable and in-depth conversation, not just about this book, but about the topic of obscenity and what does and does not meet the criteria of the Miller test. My wheels are spinning. Fran, listen, Liz, when I read that before hopping on here, because the thing too for me was I'm like, okay, author Tori Woods has been arrested, is now out on bail, will be going to her local court next week. I was like, whoa.
Yeah.
For me, and this is just me personally, and maybe I'm the problem, who knows? But I was happy with the book being removed and it not being platformed, meaning it was removed from Amazon, it was removed from Goodreads, it has been scrubbed from the internet, and so on. But then we saw it escalating, people calling her work, people posting her public information, her private information publicly, who's her employer, making the calls and all the things, to the point where obviously now she has been arrested. We will learn more. Obviously, when this goes to court, I'm sure local news reporters will be on top of this and reporting. We will learn more about what law, if any, they will be applying to this. But as it stands right now, she's facing 3 charges as it relates to CAM material. So from creating to distributing to all the things, let me actually find it so I'm saying the right things on here. Again, this is available on news.com.au. So yeah, it's CAM, possessing CAM material, disseminating CAM material, and producing. So yeah, so from possessing to producing to disseminating, because it also noted that they seized, after having a search warrant, several copies. Listen, man, I don't want anyone coming in my house and seizing my books. I'm just saying. But it definitely, it makes us have to think and question what is next. Even though it's fictional, we in America, we have a criteria, the Miller test. Again, let us romance readers and just readers in general get familiar with this, because who knows what might happen. We might be hearing about this in future. Liz also went on to say, that's it right there. It's all subjective. A lot of things are subjective, but it's just like our judges, right? We have laws and each judge has judicial, what's the term? Discretion.
Mm-hmm.
They decide. You can recommend, okay, someone should get 6 months in jail, but the law says 2. And the judge is like, even though the DA told me 6 months, I'm going to give you the whole 2. Or I'm going to give you what, you know what I'm saying?
They also have like leeway to interpret the law. So it's like, okay, this is how I read what's there because it's kind of ambiguous. And this Miller test, I didn't read the criteria because, but as soon as you said, this is the case law and this is what's going on, my mind immediately went to somebody will interpret it however they see fit, and somebody will take in their subjective mind, they'll just interpret, okay, this is the material I'm reading, it applies.
Just bringing it back to the DOJ and their standard, as you mentioned, Francesca, the 3-prong test. Again, links in the video's description so you can read more, because they do have a citizen's guide as to what is the test, and also just how you can know whether or not, if this is considered obscene and what the federal law is on it. The first one is whether the average person applying contemporary adult community standards finds that the matter taken as a whole appeals to prurient interest. Example, abnormal, unhealthy, degrading, shameful, or morbid interest in nudity, sex, or excretion. That's what it said. So whether it's taken as a whole, if it appeals to prurient interest based on adult community standards, whether this is the second test, whether the average person applying contemporary adult community standards finds that the material depicts or describes conduct, sexual conduct, in a patently offensive way. And it gives an example whether these ultimate acts, normal or perverted, actual or stimulated, and all these functions and things that I'm not going to read here on YouTube. And then the last test, whether a reasonable person finds that the matter taken as a whole lacks serious literary, artistic, political, or scientific value. That last one right there. Whether a reasonable person finds that the material taken as a whole lacks serious literary, artistic, political, or scientific value. Any material that satisfies this three-pronged test may be found obscene. And federal law prohibits the possession with intent to sell or distribute obscenity, to send, ship, or receive obscenity, to import obscenity, and to transport obscenity across state borders for purposes of distribution. Although the law does not criminalize the private possession of obscene matter, the act of receiving such matter could violate the statutes prohibiting the use of the U.S. mails, common carriers, and all the things. USC section 1460, another one, 1461, 1462, and 1463. It's a whole thing, everyone. It's a whole thing.
That's way open to interpretation. Ooh, that could be anything.